Yes, hey, good afternoon, everybody. Happy Monday. And I'm the one with the hair of the two of us. And I want to just briefly mention a little bit about our backgrounds. Ford Harrison is a labor and employment law firm. It's a national law firm. I'm in our Atlanta office. Ben's in our Charlotte office. Ben and I practiced in Atlanta before he moved off and away. I've been with the firm off and on now since 1996. And Ben just rejoined us earlier this year and has a couple of decades under his belt as well. We're here to walk you through the Paycheck Protection Program, and in particular, the more recent changes that we've had as of June 5th, when the Flexibility Act was enacted, crystallizing some components of the Paycheck Protection Program, as well as clarifying a number of issues that we're going to go through in this short time period we are together. So Ben, if you don't mind kicking off, and we'll take it from here.
Yeah, great. Thanks, Jeff. So as probably most of you know, the CARES Act was passed by Congress back in March. It was a very large bill. It committed over $2 trillion in economic relief to businesses that were affected by the coronavirus pandemic. And part of that act was the creation of the Paycheck Protection Program. And that, generally speaking, allowed companies with 500 or fewer employees to be eligible for forgivable loans. And there was also an exception in the CARES Act that allowed larger companies to participate as well if they were in the restaurant or hospitality industry, because those were particularly hard hit segments of our economy. The Paycheck Protection Program was very popular. There was some hiccups in the beginning, some problems with the website and lenders not necessarily knowing what they needed to do to process these loans. But after that, those kinks were sort of worked out. The initial $350 billion went in just 13 days. There was just a massive amount of loans that were processed, and it actually ran out of money very quickly. And so in April, Congress approved another package that put another $250 billion into the program and extended the opportunities for borrowers that didn't get in on the first tranche of money. One of the interesting things for people like Jeff and I is that as popular as the program was, it left very many questions open and a lot to interpretation. It was a very large bill that passed very rapidly, and there was many unknowns. And the questions began coming in really almost immediately as borrowers and lenders sought to get these applications in. And so what happened is, over a 2-month period, the Treasury Department and the Small Business Administration sort of trickled out some guidance in the form of FAQs and interim final rules that gave us some inclination or direction on many of these questions. But again, it left a lot of points open, and in some cases it actually led to further confusion, and we'll talk a little bit about that. But that's what we had to work with to date, is sort of checking almost daily to see if there was any new guidance from the SBA or the Treasury. More recently, in June, and during this month, the Payroll Protection Flexibility Act passed, and this is an amendment to the CARES Act that makes loan forgiveness under the PPP much easier to obtain. And you can tell that the entire direction of this amendment is to get companies the money, allow them to use it in ways that keep their businesses open and their payrolls flush, and to, at the other end of this, to be able to achieve full forgiveness or somewhat close thereto. And while there are some questions that linger, this has been a really welcome development for employers who have been really hard hit by the coronavirus pandemic, and this is really welcome news, I think, for everyone in using those funds, and as well as being able to achieve forgiveness for those funds.
So thanks, Ben. One of the primary changes brought on by the Flexibility Act was the extension of the covered period of the loan from 8 weeks, which is what it was before, to a period of forgiveness to 24 weeks or until December 31st, 2020, whichever is earlier. Obviously and clearly, this allows more time to spend the loan proceeds, particularly for businesses that are still closed or partially closed. And Ben and I represent, for example, a number of hospitality clients, and hospitality clients are the paradigm or the perfect example of companies that for which the PPP was enacted, and they've thought, and in some senses had spent their PPP money on having their employees sweep floors or try to do some sort of marketing projects because there wasn't anything that they could do. This clearly allows for a greater opportunity to spend the proceeds, and as Ben was saying, is a welcome addition.
One of the items in the Flexibility Act is that it allows borrowers the choice of this new 24-week period or the original 8-week period if their loan was dispersed before the amendment. And that's sort of brought up questions for a lot of clients of why would I do one or the other? Why would I only use an 8-week period when I could use a 24-week period? And it really just depends on the sort of circumstances, in particular the business circumstances of the borrower. And again, this goes to the increased flexibility with the loan program. For example, if you are a company that received your loan disbursements before the amendment, you might be well on your 8-week period, or maybe even past your 8-week period, and you are at a place where you're ready to go back to your lender and go back to the SBA and seek forgiveness. And for those folks, it probably makes sense to keep the 8-week time period for the covered period in place. Alternatively, there are some companies who have taken the loan proceeds, used them to their best advantage, and to keep their business going as best as they are able. But they can foresee down the road the need for layoffs because the level of business simply isn't going to return to what they had been doing, back in February of 2020. And so for those folks, they may want to close that 8-week period and put their forgiveness application in with their lender as soon as they're able, because if they were to extend it to 24 weeks, there would necessarily be additional layoffs that could really affect their forgiveness possibilities. Alternatively, if you're in the category like Jeff suggested of restaurants in particular, there are a number of restaurants in the country that still aren't open. Some are only open at 50% or 25% capacity. And so there isn't really as much for you to spend your loan proceeds on today because your business simply isn't fully operational. And for those folks, there's a lot to be said for this 24-week period that really gives them the opportunity to have the time for their business to come back online and for the need for all of the full complement of employees. And this gives that opportunity rather than sort of spending what you can or wasting it, as some companies have had to do before seeking forgiveness. There we go. There's also an alternative covered period, and this again allows more flexibility for borrowers. The alternative period is actually just contained in the loan forgiveness application, So it's kind of an interesting place to receive guidance. But we take anything we can get really with the CARES Act. And what this says is that prior to this option being made available in the application, the 8-week period ran beginning on the date that the borrower received the loan funds from the lender. And it would be 56 days from that point as would be the covered period. But a lot of questions arose where that would be in the middle of a pay period, or perhaps the end would be in the middle of a pay period. And so a lot of borrowers had a lot of questions about where exactly should the payroll fit. Does it go in the beginning? Does it go after? Is it the payroll that is the time worked, or is it when it's paid? And many people had questions about that. And so one of the things that we have now is the option to have the 8-week period begin on the first day of the pay period following the disbursement of the loan. And what's great about that is it basically allows you to move your 8 weeks so that you can capture as many potential payrolls as possible, all of those going towards the payroll costs and the forgiveness. And so this is a nice option for those borrowers who choose to use the 8 weeks but want to line it up with their actual pay periods.
So thanks, Ben. The other, it's not the only other, but the other primary change about the PPP under the Flexibility Act is before we were required to, when seeking a loan, apply no later than June 30th, but now we have until December 31st to seek a loan. And as Ben was talking about in the earlier slides, this money initially went so quickly that many people were shut out of getting their PPP fund. They opened it up again, and now there's still about $150 billion in PPP funds that have not yet been sought after. And what's surprising to me, and we bolded it, is we often hear, and Ben and I have most often been helping clients where the loans were more than $1 million, but less than 1% of these loans are for those clients. And the overwhelming majority, obviously, is then for loans less than $1 million. And that means that there is a great likelihood that if you otherwise meet the qualifications to seek a loan, that you can get this loan. So it's important to understand that there is still money out there to be had. And if you are working with a client that may need your assistance, be certain to encourage them. As Ben put at the bottom of this slide, of course, you can only apply once for a PPP loan, but nevertheless, there's still opportunity out there. And Ben, I just wanted to get your thoughts quickly. I mean, there are clearly some companies that will not be able to apply for, including publicly traded companies or those that quote unquote have access to capital markets, like any or most company that is going to get their money from private equity. But I wanted to get your thoughts now, Ben, if you have them, on potentially companies that might not have sought these PPP funds that very well ought to consider getting them now.
Yeah, I think that's right, Jeff. There were several companies that were larger and even publicly traded in the restaurant industry that received these loans, and really sizable loans because they have many, many employees. And there was sort of a public outcry about that, about companies that were publicly traded and had access to capital markets and other sources of liquidity. And there was a real backlash. And President Trump even mentioned some of those companies by name during his coronavirus task force conference calls and video calls. And as a result, several of those companies tried to give the money back, and the Treasury Department even set up what they call the Safe Harbor, which is, you could return the money and it would be no harm, no foul if you shouldn't have been seeking the money in the first place. But I think that had a greater effect than just chilling the publicly traded companies. I really think a lot of companies got scared of the ramifications of seeking these loans if it would later be determined that they didn't deserve them or that they shouldn't be the right recipient of them. And I think that's really been why so much of there's still almost $150 billion left. But I do think that those companies that would have been borrowers under this program that got some cold feet, I think they now have reason to feel very comfortable and confident that they can apply for these loans, make the requisite certifications, and receive full forgiveness. And I think if you're publicly traded, that's probably not you. And if you are owned by private equity, that's probably not you either, because your employees' count will be aggregated with the count of all of the operating companies that the private equity owns. And of course, it's harder to say to a lender or to an SBA official that you just didn't have any sources of liquidity when that's really what you have above you is these institutional investors.
Thanks, Ben. So the other major change, of course, is now, whereas before you had to spend at least 75% of the loan proceeds on quote unquote payroll costs, which we'll get into a little bit, or maybe somewhat vaguely defined. Now you can reduce that threshold to at least 60% of the proceeds being spent on payroll costs. And of course, as we've alluded to now a couple of times, that is really providing some great relief to employers who were going to have a difficult time spending those proceeds on payroll, given the fact that it's quite difficult for some of our clients to bring back and spend on the level that they were required to spend under the PPP. Of course, the remaining 40% can be used for mortgage interest, rent, and utilities. And if you don't mind, going to the next slide so we can talk a little bit about the what these funds must be spent on.
Yeah, and so in addition to the really good news that Jeff just relayed, that the threshold for payroll expenses was lowered from 75 to 60%, meaning that companies can devote a larger portion to some of those other items like mortgage interest and rent, some of those things that are necessary to keep the business going on, particularly when there aren't enough employees to sort of fill up the 75% side of the ledger. And so that's a really good development. But along those same lines, a good development followed the amendment of CARES Act. And what happened was before, it was interpreted by many people that if you didn't devote at least 75% of the loan proceeds towards the payroll cost category, that there would be no forgiveness available, and that it was a threshold that meant if you didn't divide it in those 75-25 splits, then you would not be eligible for any forgiveness, rather than just having reduced forgiveness. And when the act was amended by the Flexibility Act, the threshold was dropped to 60%, but the question was still outstanding whether or not that needed to happen to receive any forgiveness at all. And so just 3 days after the act was passed by Congress and signed by the President, the Treasury Secretary, along with the SBA administrator, came out with a joint statement, and those two government agencies, and one being a cabinet department, made clear that if you do use less than 60% of the loan for payroll cost during whatever your period is, your covered period, you'll continue to be eligible for at least partial loan forgiveness. And that's true of the headcount that we'll talk about, and also that portion that goes to wages and salaries and things of that nature. So this was really another welcome clarification, and one that I think will result in a lot more borrowers clearly receiving the highest amount of forgiveness that they're able to, even if they can't quite muster this 60% due to some of the issues with bringing employees back.
So now I want to speak a little bit about the changes to the safe harbor date in terms of spending those salary and wages before. And when we're talking about before and after, we're talking about before the June 5th Flexibility Act went into effect. But before that time, if there were reductions in salary or wages, payroll costs of one or more employees as compared to the measuring time period of February 15th, 2020, and you essentially had to ensure that we got those salary and wages up to that comparison period no later than June 30th. Now, the Flexibility Act extends the safe harbor period for restoring salary or wages to that required level all the way to the end of this year. And I was asking Ben in advance of our webinar, well, does that mean then that if you wait until December 15th to bring your wages up to where they were as of February 15th, then you're okay? And my understanding, Ben, is that's exactly right. If the company needs to wait until that time period to restore wages to the requisite levels for full forgiveness, they can wait until toward the end of December.
Yeah, that's right, and it's been described just as that, a safe harbor, that if you can make it back to above 75% of the prior salary and wages by those dates, then you're safe and you're there for full forgiveness.
Great, thank you. So let's talk a little bit about something that Ben was mentioning before, which is our headcount requirement. The rule under the PPP is that you calculate your average number of full-time employees per month, and we'll talk about how you do that in a little bit, using the most favorable look-back period. Then using your average full-time employee number, you hire back the requisite number of employees to ensure that your average full-time employees during the loan forgiveness period meets or exceeds your comparison number. Before the Flexibility Act was put into place, if there were reductions in headcount, that would not decrease the loan forgiveness amount if there's a reduction in full-time employees as compared to your February 15th, 2020 time period, and no later than June 30th, the borrower fully eliminated the reduction. And now, as with the previous slide, it extends the safe harbor period for rehiring employees until December 31st, 2020. In other words, getting those numbers up, we now have a full 6 months more to get your full hire, as close to full hire as possible. And I hate to sound like a broken record, but if you look at the rationale behind putting the PPP in place, the entities that were most hit were in the hospitality arena, whether they be hotels, restaurants, or similar types of businesses, and they are simply, some of them are simply closed now. And instead of having to worry about giving fictitious duties to employees, there is a real opportunity to effectively get your numbers back to the required numbers, and again, meet the rationale of the CARES Act and more particularly the PPP, which is to get as many of your employees back on the payroll as possible.
Another really great, in my view, development from the Flexibility Act is that before the act was passed, the Flexibility Act was passed, the CARES Act allowed employers to defer the employer's portion of the payroll tax for their employees. And it was a great thing because you could defer all of the employer portion for the remainder of 2020, and you would only have to pay half of it back by December 31st, 2021, and the other half by December 31st, 2022. And so it gave you a nice savings of, well, I guess, over 5% on your payroll costs, and it really favorably allowed you to not repay it for quite some time without any interest or penalty. And there wasn't a program that you had to apply for to be able to do this. You would just be able to do it if by not making the employer contribution and noting that on your tax forms. And the problem, though, was that the CARES Act specifically said that you cannot defer the payroll tax if you're going to seek forgiveness from a PPP loan. And so a number of companies, of course, thought it would be better to have a fully forgivable loan than it would be to temporarily defer the payroll tax. But one thing that is nice is the Flexibility Act retroactively eliminated that provision. And so borrowers now can seek full forgiveness for their loan proceeds, and they can take advantage of this deferral. Now, the fact that it was made retroactively means that there are payroll taxes that were paid during a time that now could have been deferred. And the Act doesn't tell us anything about how one might go about getting a credit for that money or even have it repaid once you send it to the Treasury Department. It might be pretty tough to pry it out, but that's an open question that we probably will see some more guidance on. But for any of the borrowers in the PPP program who have not taken advantage of the tax deferral, you definitely want to do that. It's well worth it.
So what happens if you are doing your best as a company to rehire the employees that were furloughed and you can't get yourself up to the requisite FTE numbers to get full forgiveness? Before, it was very unclear in terms of what would happen if someone refused employment, someone resigned, or if you had to terminate an employee for cause, would that count against forgiveness? Now, yet another safe harbor provision makes clear that you do not have to count against forgiveness if a company can show it was unable to rehire those employees and could not fill those vacancies with similarly qualified individuals. And where this really came up a lot, and still is at least given a lot of voice, is the fact that also under the CARES Act, there is a very rich unemployment scheme for those individuals who were furloughed or let go because of the pandemic. And as you guys probably know, as long as you get $1 under any state unemployment compensation scheme, then you would get the $600 at least through the end of July of this year. And so there's a real scenario, although probably not as often found as certainly we hear, but there's a real scenario where employees are being paid more to be out of work than to actually return to work. And so what we have been doing and what Ben has been counseling his clients to do is we've been drafting communications that make clear that on such and such date, we're unequivocally offering you your position back at the same rate of pay, doing the same thing. And you know, we assume that you'll show up, and if you don't, then you may not be entitled to any further unemployment. But in any event, please do let us know, something along those lines, more artfully written than I've just stated. But that type of communication is now necessary to ensure that you can get full forgiveness for your clients. And that goes the same when you're terminating someone for cause, or if you have an employee that has resigned and you just can't get someone in place that's similarly qualified. So it's a matter of record keeping and making sure that you use the appropriate documentation when someone is declining to come back, either because of unemployment or because of COVID or other health reasons, or a real fear of returning to the workplace. All of those are not valid reasons to potentially lose your full forgiveness.
Yeah. And I think the one other thing that I would add to that is that the documentation that you talk about with respect to employees who choose not to accept an offer of reemployment, that written documenting also applies to the termination for cause. Even if it's kind of a self-serving document, you'll want to put something together that is written and indicates that employee was let go for cause, so that your lender can see that and can not count that person towards your threshold for FTE.
So this one was fascinating to me simply because we had to, Ben and I had to handle this real time with some of our hospitality clients, and that was, how are we defining a full-time employee? You know, particularly for those types of companies that use a lot of part-time employees. This one was a little bit concerning because remember when the CARES Act was enacted in the PPP in late March, we didn't have until May 22nd an interim final rule that helped us understand how an FTE was being defined. And now under the amendment, which essentially crystallized the interim final rule, we are really looking at a full-time employee defined by the number of hours that each works per week divided by 40. So if you have, 3 employees, each working, 13 and a third hours, those 3 would equal full-time employee. Or as Ben put that example below, if you have 4 employees working 10 hours a week, then they're each worth a quarter of an FTE. And that really does help, particularly because, as you see in the last line of the what's happened now, we're able to identify an FTE equivalency of at least a half of an FTE for someone who's a part-timer. So we very well may be able to get up to full numbers with a workforce that has a large number of part-time employees by treating each of those part-time employees legitimately as worth a half a full-time employee, as opposed to treating them based on the number of hours that they work divided by 40. Ben, I didn't know if you had any other thoughts.
Yeah, no, you're right. And it makes the math interesting because particularly things like restaurants that have a lot of part-time employees and employees that are often working while they're in school or the like, and so don't have very full schedules. You could have 2 employees who work on average of 10 hours per week, and therefore would normally be 0.25 FTE and 0.5 together. Under the simplified approach, you can count them as 0.5s, and in essence, the 2 of them create 1 full FTE, even though they only work 20 hours a week. There's a new safe harbor in the PPP Flexibility Act that is brand new, and it amends the CARES Act to include this. And what this has to do very specifically was with those businesses that are prevented in some way from either opening at all or opening at full capacity. And there was a lot of questions for those businesses that were wondering how they can possibly get back to their original February 2020 business activity levels when there are restrictions, whether they be from state agencies or the federal agencies, or it's just complying with directives or guidances from the U.S. Department of Health and Human Services, the Centers for Disease Control, or OSHA guidance. And so this amendment provides another safe harbor for those borrowers who can show that because of restrictions, because of guidance issued by these governmental agencies that either keep your business closed or prevent your business from returning to those levels that you had back in February of this year, there's a safe harbor that says that won't affect your forgiveness. And I think it remains to be seen exactly how the math will work out on that. But this is going to help a lot of employers, particularly those that are still under some sort of restriction that prevents them from reaching those their full business capacity. And it's not hard to think of those. They are restaurants, they are movie theaters, bowling alleys, amusement parks, sporting events, those kinds of things where there are certain restrictions that are due to the COVID-19 virus and customer and employee safety that has prevented those businesses from opening at all, or opening and operating at the same level that they had previously been at.
So we're reaching the end, and I know we've got a number of questions there, so we'll try and hustle ourselves so we can answer some of those questions. But one thing that I mentioned earlier that I'm following up on is what is considered payroll costs. There was definite lack of clarity before in terms of what was included in payroll costs, and now the interim final rule, which has made it into the Flexibility Act, makes clear that bonuses and hazard pay you're typically seeing when you've got your manufacturing and other types of employees that have had to come to work, are being paid additional by those companies to come back to work. Those costs are included in payroll costs, and that's really important and helpful. Again, Ben started this conversation by saying this is really it's pleasant when Ben and I can talk about employer-friendly legislation that really is also quite employee-friendly, and this really does allow employers quite a bit of flexibility to spend up to the requisite threshold in order to get full forgiveness. One thing that's not mentioned here that has been in the early rules and has still made it through the final rules that, again, I felt was quite interesting is severance. Severance payments can, on the one hand, they seem to work against making sure that you have your full-time equivalency, but on the other hand, since severance pay can be used as a form of payroll costs, there are smart ways where companies can use severance to part ways with employees that are not meeting their business needs, and then try and hire up to make sure that you're meeting the threshold numbers.
As we are concluding this part of the presentation and leaving some time for questions, we thought it was good to revisit the loan forgiveness process itself, because we have a lot more clarity about exactly what that process looks like and sort of timing expectations as well. The forgiveness process starts with the borrower providing a forgiveness application along with the supporting documentation to the lender. And that's how the process begins. So you go back to your local bank, whoever you may have received the loan from, and it's important that you take a look at the loan forgiveness application that the Treasury Department and SBA has published, because it tells you exactly what you need to do and what you need to show to receive forgiveness. And that's the document that it all starts with. The lender then has 60 days from the submission of that application to make its determination about the amount of forgiveness for that particular borrower. So, at least in the initial step, it will be your lender rather than the SBA making that determination. Within 60 days, that is submitted to the SBA, and then the SBA has 90 days after that to review the application and make its forgiveness determination, either sort of agreeing with the lender or disagreeing on some points. And then the SBA will fund the loan forgiven amount so that the lender's not out that portion, and along with interest to the lender. And so you'd be looking at really a 150-day process is what at least the guidance and the law requires of the lender and of the SBA. One thing it's important to note is in a frequently asked question, the Treasury and SBA announced that it was going to scrutinize all PPP loans in excess of $2 million. And this is a point that was made during a time when the government was trying to make clear that it was not going to accept large companies with, publicly traded companies or private equity-owned companies that shouldn't be getting this loan. They're going to scrutinize those larger loans. And so every indication is that loans of less than $2 million are really not going to receive the level of government oversight that those over $2 million will. And as Jeff talked about earlier, 1% of the loans have been $1 million or more. And so this $2 million threshold means it's a very small scope of the SBA's review, and it really will be towards those large companies that have high payroll, which allowed them to have high loan amounts. And, what happens if you don't get full forgiveness? What happens to that remaining portion? There's good news for everyone here, again, with the Flexibility Act. The original CARES Act PPP program had a 1% fixed interest rate on these loans, and it is capped at 1%, so that's a very favorable term. But the other thing that's happened here is the Flexibility Act amends the program, and instead of the original 2-year maturity, it's now 5 years, and there's no penalty for early repayment. And so if you can't get all of your loan forgiven and you are going to have to pay off the remainder, to have 5 years at 1% to do that makes it a pretty attractive loan. Those are pretty favorable terms on those loans, and so it really just makes, again, even for that portion that's unforgiven, it really makes it bearable for borrowers and to use this money. It is automatic for any of the new loans that are issued after June 5th, but those issued before June 5th, the Act specifically allows the borrower to go back to the lender and extend the maturity date to 5 years by agreement. Another nice feature with respect to repayment of unforgiven portions is that the Flexibility Act extends the original 6-month deferment of payments to a open time period, which is the date of the forgiveness determination by the SBA. And the reason that's really great is, we talked about that 150-day time horizon. If you had an 8-week covered period and you added another 5 months to that, that's 7 months at best. And so you may end up having to make payments on your loan at a time when you're still seeking forgiveness for it. And so what is nice is that this has been extended beyond the original 6 months to make sure that you don't pay anything if you're not going to be having an unforgiven portion. And the last thing we would note is sometimes our clients ask us, what do you do with this unspent money if you're not able to put it all towards payroll costs or those other items like rent and utilities? One thing is you can just repay it to the lender, and there's no penalty for that. But the other thing is to keep it as a very low interest, long-term loan that there's no penalty for early repayment on. And so that can be a pretty attractive source of funds, especially at a time when things are still pretty difficult in the economy.
That's it, everybody. And I know we have some Q&As. I'm not sure how we're going to, remind me how we're going to handle that, and we'll do our best to answer as many as we can at this point.
Yeah, we've got about 3 minutes left, so you guys are welcome to try and answer some of those if you can.
Okay, yeah. Well, I see there's some good questions in here, and we'll be happy to answer more questions offline, but respectful of the time here. But one question I just noticed was if you choose to do the 8-week period rather than 24 weeks, do you have to wait the full 24 weeks before you apply for forgiveness? That's a good question, and the answer is no. The answer is really that you can apply for forgiveness anytime after your covered period ends, and so you could do that right at the end of your 8 weeks if you had the payroll documents and the like to go to the lender and demonstrate for your forgiveness application. So you don't have to wait. You can get that process moving quickly. And, I think for a lot of companies that in particular have used their local lender that they have a business relationship with, I think that those are going to be pretty fast reviews by the lenders because they will have familiarity with the borrower. They will have the sort of shield that the SBA has given them, which is to say they can accept representations from the borrower as true, so they don't have to really dig any further. So hopefully that's another way that this is sped up a bit. It's hard for me to see it going quickly when it's at the government level because nothing seems to go quickly at the federal government level, but that's a way to move your application on quickly. Let's see here. Oh, good question. There's a question about when we can expect new updated loan forgiveness applications. It's a really good question. There's no requirement that the SBA put that out in any specific time period, but I do know that it was a point of discussion that borrowers are going to want to see that as soon as they can. And so we'll be on the lookout for when the SBA comes out with that new forgiveness application, but it should be very helpful because it'll be geared toward the changes from the Flexibility Act that have occurred with respect to the CARES Act. So I think that'll be a very useful tool for everyone as they go seeking forgiveness for the loans. And I think we're right about out of time, but as I said, and Jeff and I would be happy to answer questions offline as well. But thank you, everyone, for your time.
Thank you, guys.
Thank you guys very much.
Take care.